Good morning, everybody. Thank you for joining us. And we are going to be discussing a very serious topic. This topic came to me, probate versus a trust, dealing with my own family. And the lawyer that you're going to hear from this morning, Mr. Dimitri Avastov, is the lawyer that I had and my family acquired to help us in a very serious situation dealing with my brother. And from that experience, I started really looking into what is going on with families who have trust and versus families who don't, or families who just have wills and not a trust. What happens to them? So it really opened my eyes, and then also it really let me see how much help professionals that people need. So I decided to start specializing in probate. I am a real estate probate specialist, helping people that end up in probate court with their real estate property, where Mr. Dimitri is a person that helps you with your planning and try to keep you out of the court. So I want to thank him this morning for taking his time out. He's a very busy individual, and taking his time out to really tackle this problem with us is when I'm gonna call it a problem situation, because once you get into probate court, you're up to the judge's mercy, and you could have prevented that. So I like to start out by reading Mr. Dimitri Avastov's bio. Dimitri Avastov, the founder and managing attorney of Forward Estate Planning. Dimitri is a Los Angeles-based estate planning attorney. Dimitri has drafted dozens of estate plans for clients all over California, and has been actively providing the communities around him with the value and knowledge of these important services. After working for traditional law firms and serving as an in-house counselor for companies and startups, attorney Dimitri Avastov was inspired to set off on his own in order to provide better, faster, and more modern legal services to the people in the communities around him. The result was the founding of Forward Estate Planning, a law corporation. Dimitri realized long ago that modern law firms should not be restricted by the 9-to-5 work week schedules, expensive and unnecessary overhead, and the fees that line someone's pockets. Instead, modern clients demand services that are on their schedule, fit within their budget, and give them exactly the result they are looking for without the runaround. Forward Estate Planning provides estate planning, attorney services, representation, and custom legal solutions, including probate, trust administration, and drafting of wills, trusts, healthcare directive, power of attorney, conservatorships, and guardianship. So this morning, he's going to answer 3 questions for us. What is an estate plan? Number 2, what documents are part of a typical estate plan? And 3, why do I need these documents? And Mr. Avastov, if I can, I'd like to add in a 4th one. Can you explain to us why this is so prevalent in the minority communities? Because when I'm seeing it, I'm going to the courts and I'm looking, and as I'm getting leads on people who are in probate, I notice that the majority of the list that whether I pay for them or whether I go to the courts, is saturated people that are of color. So I'm hoping that you will also put that on as a 4th, from your experience as an attorney, why that may be so. So from here on, I'm going to turn it over to attorney Dimitri Avastov.
Hi, everybody. Sherman, thank you so much. That was a wonderful introduction. If it's possible, it would be great if I could see people's faces if they turn on their video, unless you're in the morning and you're putting your makeup on, whatever it is. I have no problem with that, but it's nice to see people when I speak to them and when I answer their questions. Otherwise, Sherman, why don't I start with your fourth question? I think that's the important question, and why everybody needs to perk up and listen to maybe what I have to say and look into this further. So the reason why that happens, and the reason why so many minorities fall into probate courts, is because they either don't have the resources or the knowledge they don't have the availability to know sometimes of what these estate plans are and how they protect them from falling into probate. And the reason for that is actually very simple, because when you purchase a home or when you open a bank account, you put it into your name, and that's very standard. So when you purchase a home, they, for example, ask you, who do you want this home to belong to? And you just put your name down, okay? Now, what that does, though, is that the courts and the county, when you record your name as the owner of the home, they don't know who that home should belong to if you pass away. So what happens is that because the house is in your name, your estate is now subject to probate in order to pass this house to your rightful successors. You would think that your children are automatically the beneficiaries of your home, or your single one child, or your multiple children, but that is not so. And the county doesn't know that, because what if somebody wishes for your children not to get anything, okay? So here's the problem with these documents and falling into probate, is that if you don't prepare these documents now, you're most likely going to end up in probate. And the reason a lot of people don't prepare them now is because they either don't have the knowledge about what they are and how they could benefit them, first of all. And second of all, they sometimes don't see the value in spending $2,000 to $3,000 right now in order to then avoid huge complicated problems in probate court and losing tons of attorneys' fees and tons of expenses into having to administer probate, okay? So I don't want to lose anybody, because I can talk about this for hours, but I just want to give a basic perspective of what probate is, okay? So probate, the word itself, don't get confused. Lawyers use fancy language, but probate is just a fancy word for proof. It means you have to go to court to prove that you're the rightful successor to real estate, to a bank account, to cars, to life insurance proceeds, whatever it may be, okay? So when you go to probate, and the reason you fall into probate is because there's no other way to dispense of that property. And for example, the court is not the problem. The problem is these institutions. So either the mortgage company or the county, Los Angeles County, or Bank of America or Wells Fargo or whatever it may be. They require some kind of proof for you to become the rightful successor to somebody's account. And if somebody, let's say Mr. Dimitri, has passed and all of my assets are into my name only, neither Bank of America nor the court nor the LA County or any other county for that matter, they don't have any understanding of who this property should go to, okay? So here's what happens. So what happens is that when somebody passes away, their assets have to be submitted into court in order for that property to pass to the rightful successors, okay? So is everybody with me so far?
I can see yes.
Okay, all right, sounds good. There's a lot of silence, and I'm just hearing myself talk, so I don't want to make it awkward for anybody, okay? So I'll just keep going. And what I want to do is actually, I just want to show you one slide. You don't need to take notes or anything, because I can email it out to Sherman afterwards or to everybody. So I'd like to share my screen and show you just one slide, and then I'll just keep talking about what I'm talking about. You've seen my face. You don't need to see it anymore. I'll show you the actual information that you're looking for right now, okay? Oh, so Sherman, the participant screen sharing is disabled. I can't hear you.
I said it should not be.
Okay. Well, if it's disabled, I can keep talking, but it's better for everybody to see.
Maybe I'm the one that had to.
See if you can do it now. I made you a co-host. So let's see if you should be able to share now.
Okay, great. Yes, I can. Okay. All right. So can everybody see my screen?
Yes.
Yes.
Okay, great.
Yes.
Yes.
So that's just the basic slide with my information on it. I'll share that later too. But let me see if I can switch that slide to the next one. Okay, can you see my screen now?
Yes.
Okay, so we're looking at living trusts versus probate. As I discussed, probate is proof to the court that you're the rightful successor. The reason you have to go to probate is because neither Bank of America or LA County know who should this property belong to or who should it pass on to, okay? So if you pass away without having prepared any type of document to show who the rightful successors are, then you will have to go to court in order to prove that. There's certain exceptions for that. We don't need to discuss that here, but generally this is why this happens. And to answer question number 4 from Sherman, the reason why minorities are so affected by it more so than others is because they don't either have access to this information up front, or they are unwilling or are skeptical of spending money now to prepare these documents in order for that not to be a problem down the line. And sometimes it's an inability to spend that amount of money now. What used to happen? Let me tell you this. What used to happen is that people used to have wills. And you see this in movies all the time. Oh, I drafted a will, and in a will, I want, 10% to go my oldest daughter, 90% to go to my younger son, okay? The problem is that in California, a will still has to be submitted to probate court. So a will not distribute this property. The county will not use the will to distribute the property. The Bank of America will not use a will to distribute the property. You still have to take that will, submit it to court, go through the proceeding of the proof of probate in order for that property to pass to your rightful successors. Okay, if you don't have a will or a living trust or anything, then the probate court will distribute everything by default, okay? If you have a will, you still have to show that you're the rightful successor, and you still have to distribute it according to will instructions. So a will is never enough anymore. Maybe it used to be, but even before, you still lose money for when trying to administer this probate. Okay, so my first point in the living trust versus probate is that I just outlined there's 4 documents there: living trust, will, durable power of attorney, and advanced healthcare directive. And I want to go through each of them really quickly. And then if there's questions down the line, I can answer them more. But basically what I do is that I create estate planning packages for my clients that include a living trust and all the other documents that are necessary for it, a will, a durable power of attorney, and advanced healthcare directive, okay? So the living trust is the operative document. That's what you create in order to transfer your assets into it or name the living trust as the beneficiary in order for the assets not to fall into probate. So I guess I should address what the living trust is versus the probate, because that's the main core of our questioning. Is that what a living trust does is that it's a set of documents that once you transfer assets into it, once you create it and transfer assets into it, those assets will not be subject to probate proceeding. It means that those assets, Bank of America, LA County, all these institutions, they can take that document and they can transfer the assets to the rightful successors in the percentages that they're supposed to go based on the living trust document alone. There's no need to submit it to court. This is a private document, and I will go through benefits of it on why do I need these documents, okay? So that's the living trust. What you're creating is a set of documents that you sign and notarize. And basically they say who gets what in what percentages, which assets are part of it. And then those assets are no longer subject to the court proceedings to prove who the rightful beneficiaries are. Okay. I want to take a pause and see if people have any questions right now without going into details of why that's important, just to not confuse anybody.
My name is Chanel, and I do have a question. I wanted to know, how do you find out who has the living trust? So so in my case, personally, my son's father left a living trust, and I don't know who is the trustee.
Mhm.
So how do you find out who the trustee is?
Okay, I can answer that question. I wanted to see if there's any questions that are related to what the living trust is in the first place, but then we can do a little bit of like Q&A of problem
Okay, you can
solving
swing
later.
back around.
But
Sure.
the quick answer to you is that, and that's important for me describing what a living trust is that a living trust is a private document. It does not get filed with the county. And the trustee, and usually the beneficiaries, are the ones that hold a copy or the original of the living trust. Okay, so which means that if you think you're the beneficiary of a living trust, you should find out who the trustee is, and you should find out and ask them or request them for a copy of the living trust documents if you believe that you're the beneficiary. Okay. And then there's a lot of problems with, if people are resisting to do that, but we're not going to get into that right now. Okay.
Okay.
Okay. But does anybody have a question about the definition of a living trust, of what that is? I just want people not to be confused as to what that is.
Hello. I'm a little confused. My name is Karen. I'm just a little confused because a living will and a living trust.
Mm-hmm.
Is that correct? I'm not really sure. So I own something and I want my children to have it. Is that a living trust or a will?
Okay, so let me describe that for you. So that's a perfect question to identify it. And again, I wanted to get this some questions answered so we're all kind of on the same page before I move into why they're important. Okay, so a living trust is a document. It's called a living trust because it's amendable, revocable during your lifetime. Okay, meaning during your lifetime, you can make any changes that you want to it. But once you pass away, once that door closes, then nobody can make changes to it as to how to distribute property, as to who the trustees are, as to who the beneficiaries are. Trustees, there's exceptions. But for the living trust, you're creating a trust that's active during your lifetime, okay? What a will is and why it's part of the estate planning package is because you still need a will just in case you forgot to transfer a bank account, just in case you forgot to transfer some kind of an asset into your living trust. The only thing that's going to say in the will is that everything belongs in the living trust. Does that make sense? So the will is basically an umbrella to just cover you in case you forgot during your lifetime to put everything that you're supposed to put into the living trust. Okay.
Thank you.
Yeah, so
Yes,
hopefully
you
that
made
answers
it
the question.
clarified. Okay,
Yeah.
I'm good now.
Okay, great. So then I'd like to move on to, before we go into the importance of these documents, what the durable power of attorney and advanced healthcare directive, okay?
Mr. Dimitri, can
Yes.
I ask you a question before you move on?
Of course.
If I heard you correctly, the will just covers in case you forgot something to put into the living trust, right?
Correct.
But without a trust and you just have a will, you're not covered. Am I hearing that? Am I hearing that?
And you know
correctly?
what, Sherman, that's a great point. So why don't I say this, is that most commonly people, you might even out of our audience here, you might just have a will right now, okay? And if you do, here's the warning. The will, first of all, still has to be submitted to probate for your beneficiaries to receive your property, first of all. And second of all, it might not properly distribute what you actually want to distribute, okay? So in a living trust, you can give a lot of details as to how things are to be distributed. And if your will is very basic and just says, well, I want everything to go equally between my children, well, good luck, because it's going to be very difficult to try to follow through on those wishes just through a will, because the court is going to make sure that that's how it's done with no deviation. Okay. So yeah, if you have a will, if you don't have a living trust, and then we're talking about California here, right? If you don't have a living trust in California, your assets are at very, very high risk to be subject to probate. So your beneficiaries will have to dig real deep in order to try to figure out what to do with these assets and how to divide them up. But let's get into the power of attorney and advanced healthcare directive, because that's part of the estate planning package. And the reason those are important documents is because living trust and a will are active when you pass away. But a durable power of attorney and advanced healthcare directive are active when you're incapacitated, okay? And you need to grant somebody authority to make financial decisions for you when you're incapacitated. And that's what the durable power of attorney form is for, okay? You don't want to fall into credit card debt. You don't want to fall into mortgage debt. You don't want to fall into unnecessary expenses or waste, or your tenants stop paying if you have an investment property. The power of attorney handles that during your period of incapacity, and it returns to you when you regain that capacity. And I will tell you honestly that from my practice, the power of attorney kicks in much more often because people get sick, and last 2.5 years, they get sick, they get into a car accident, they have dementia, they have a stroke, which they don't recover for a year. So there's a lot of different issues that could happen where somebody really needs to step in and manage your assets while you're, let's say, away, okay? And the Advanced Healthcare Directive is a document that permits somebody to make healthcare decisions for you, okay? So this is something doctors always ask for when you walk in for any kind of procedure. They say, well, do you have a healthcare directive? Do you have anybody nominated who can make healthcare decisions for you in case you can't do it yourself? Okay. So all of that is part of what I call the estate planning package. That's a very standard thing to offer to clients. And I usually offer all 4 documents, and they're not exclusive of each other. They all work together to protect you during a period of incapacity or in case something more serious happens. Okay. So now let's get into the important reasons. Why do I need these documents? Okay. Number 1 is to avoid probate. I described to you what probate is, but I want to tell you what the issues with probate are. Okay. So the courts will, they're not offended by people avoiding probate. In fact, there's a living trust type that's called probate avoidance trust. This is not some kind of a scheme to try to, finagle the government for them not to participate in your assets. This is literally what people do in order not to fall into probate. And probate courts will thank you for not wasting their time having to file cases, having hearings, paying fees for trying to administer all this stuff. Okay. So don't think of avoiding probate as something where you're hiding your assets from somebody. It's actually a way to basically minimize problems for everybody, including the courts, okay? But, so here's the issue with probate, is that it costs a lot of money, number 1. And why? Because fees on probate are guaranteed by the state, meaning the state sets those fees. It's not like me, I'm like, hey, I'll do it for $500. That's not how it works. The court permits you to charge a percentage of the estate, and those fees are set. And those fees are 4% of the first 200,000, if I'm not mistaken, 3% of the next 300,000, and on and on and on. So basically that fee percentage gets reduced with the more assets you have, but it still charges you a percentage of your estate. So if your estate, here's the difference, is that these houses that are in LA County, they used to be $50,000, $80,000 30, 40 years ago. Okay. Now they're $1 million, 700, 800, $1 million. It just really depends. That's all over the place. But that means that the fees for probate are now at least $15,000 to $25,000 just for having to file and administer this probate, okay? So what happens at the end is that they collect all the assets, including the value of your real estate, the value of all your bank accounts, the value of all your private personal possessions, and they collect all that together and they'll say, hey, it's $2 million. So the attorneys and the personal representative, they get let's say $25,000. And the problem with that is that if you don't have assets out of the probate to pay for it, then a lot of times people have to sell their house to pay for those fees, which sounds ridiculous, but that's what happens, okay? So number one is that it's costly. It costs a lot of money for the beneficiaries. And in the process of that cost, they might have to sell assets or sell the real estate in order to pay for those costs, okay? All right. There's more issues than that, but I just want to cover like real basics here in our presentation today. Okay, so number two, it's public. What does that mean? That means that you're going to submit every single name of every beneficiary, every single creditor, every single asset that the person has owned to the public for public inspection. Okay. Is that good or bad? It really, really depends. Some people are extremely protective of the assets that they own. They don't want people to know what they have, what they own. And all of that gets eliminated because you have to submit everything to court. Okay. So that privacy just disappears immediately. Number three, default. What does default mean? Default means default laws of California. Everything gets distributed according to default laws of California. Nobody's getting 10%, 90%. Nobody's getting, hey, the sister gets the bank account and the brother gets the house. That's not how it works. They're going to split everything evenly and by bloodlines only. Well, what if you have somebody you don't like? What if you have a falling out with one of your, one of your children, or what if one of your children is doing really well, and you're like, I don't want to leave really anything to them. They're doing great, but the other one is struggling. So I would want that person to have something else. Okay. Well, the court is going to say, no, everything gets split. And even this person deserves it or doesn't deserve it, they're still going to get it. Okay. And if this other person wishes they had more, well, they're not getting it. Okay. So think of it this way. Think of it in a different way. Think of it that the California state already has an estate plan for you, and it's called the California law. Okay. Think of it that way. Think that California law already knows exactly what to do with your property. Okay. They're just waiting to get their hands on it in order to do so. So the idea is, no, don't let them do it by default. Let them do it how you want to do it. Okay. All right. Another thing about probate is that it's extremely long. It takes forever. Hearings are set 3 to 4 months out. Then if something is wrong, that hearing gets continued. And then they give you a period for when you have to file a bunch of documents. And then, God forbid, somebody challenges your probate proceeding. For example, somebody comes in and says, no, you should not be the executor. Okay. And then it becomes a trial. So you're looking at something that potentially lasts 1.5 years versus potentially lasting 3 or 4 years. I just got a call yesterday about a client who said, my case is going into the 4th year of probate, and I have a hearing for the trial and I need your help. Okay. Is that what you want for your beneficiaries? I don't think so. Okay. And then it's not a final thing, but this is just one of the things that I listed, is that probate is combative, because as soon as you file probate, you have to give notice to all the individuals that a notice is required to. And you have to give them time to respond and to challenge if they want to. And that actually does lead a lot to challenges in court. Okay. People come out of nowhere saying, oh, I should be owed something. And then they will challenge what it says, even in the will. Even if you submit a will and it says it should be, 30% to one sibling, 70% to another, they'll still come in and challenge and say, no, it should be 50-50. Okay. All right. So that was number one, where we talked about probate. Number two, we're minimizing financial losses. Okay. Think about it this way. You worked your whole life to collect what we would call the estate, to, to earn things, to earn benefits, to build real estate, to kind of build an empire behind yourself, right? And then all of a sudden, what do you want? Do you want that empire to pass to your beneficiaries, or do you want huge chunks of it get gutted, and in process, certain assets have to be sold in order to just do the distribution, okay? So what you're doing by living trust is that you're minimizing all types of financial losses. Number one, we talked about fees and attorney fees. By the way, I didn't even mention that there's fees for just filing the probate proceeding, right? So you're minimizing these attorney's fees. We talked about that. Taxes, reassessments, and capital gains. Man, if I had a CPA here, they would tell you all about that too, okay? So one thing about taxes and reassessments is that they get calculated based on how the property passes on, even to a surviving spouse, okay? So in a living trust, when you create it, there's provisions to protect the surviving spouse from having to get dinged on a lot of different types of taxes that could incur if she just takes the property outright, okay? So there's a little bit of planning that you can do with living trust to avoid taxes like that. Reassessments. When you pass on the property incorrectly to your siblings or to your family members, in California, our taxes get reassessed upon a change of ownership, okay? And when the change of ownership occurs that not the way you want to, then people get hit with reassessments, okay? So if you don't plan ahead, you might get really wrecked by a reassessment like this, okay? If you think that you're gonna pass on your house to both of your children equally, and you're hoping that they're just gonna inherit your taxes, they might, but there's a lot of conditions that you have to be careful about, including the fact that if one of the siblings says, you know what, I'll just let the other sibling buy me out. When that happens, it gets reassessed 50%. And for houses that are sometimes bought back in the 70s or 80s, those reassessments jump from, the value of 400,000 on taxes or 300,000 on taxes, which is maybe $4,000 a year, to, $1.5 million all of a sudden, because the property gets reassessed. And then good luck clawing that back and proving that it should not have been, okay? So you want to avoid all that at all possible costs. And then capital gains, okay? This is a complicated thing to, really discuss in a quick meeting, but capital gains taxes are based on the value of property that increases over time. And what you want is when you pass away, you want your children to step into your shoes, so to speak, and not have to pay those capital gains taxes until they sell the property. Now, if that doesn't happen, then they might have to pay capital gains taxes on the property during probate, for example, okay? So there's a lot of different costs that might really impact how taxes are reassessed, taxes assessed, taxes for the county are reassessed, and how capital gains taxes are calculated, especially for spouses. You don't want to pay capital gains on a property that you bought if you're just a surviving spouse, okay? All right, so number 3, full control over distribution and minimize fights. All of these, by the way, are interchangeable, 1 through 9. Number 9, peace of mind. Wouldn't it be nice to know that you don't have to think about this for the rest of your life, right? Or to have to worry about it at least. So maybe that's number 1 for you. Maybe that's more important than the costs, okay? But let's go back to number 3. Full control over distribution means in living trust, you can customize how everything is distributed versus, as we discussed, default laws of California, which is to divide everything by bloodlines, okay? Full control over distribution means you want to give 10% to your neighbor, 20% to your daughter, 30% to your mother, okay? And you want to, for example, say that I want my surviving, I want one of my children to have a lifetime interest in my property. I don't want them to receive it, but I want them to just continue living in it until they pass away, okay? So you're basically describing in particularity how everything should be divided up. And those are your wishes, and your wishes have to be respected, okay? And what you're doing by doing that is you're minimizing fights by your beneficiaries or by the non-beneficiaries, maybe people that want your assets, or you orally promised them to them, but they didn't get them, okay? You're minimizing that because you're giving them instruction as to how everything should be distributed, okay? Number 4 is full control over creditors. When you file a probate or when you get into proceedings that you have no control over the creditors, they have to get paid. Before anything is distributed, all of the creditors need to get paid. And if you're out of money at the end, too bad. And by the way, number 1 creditor is attorney fees. So if your estate is $18,000 in the end, and that's all the money that we have, and the fees are $18,000, well, that's none of that money is yours, okay, or your beneficiaries. So full control over creditors in a living trust situation. When you step in to become a trustee, you take an asset collection step where you see how many assets we have and how much money is owed. And then you can negotiate with the creditors in order to determine how to pay down those debts, okay? Number 5, common goals with spouse. Wow, well, I get a lot of phone calls where the husband, for example, wants one thing, but the spouse wants another thing, the wife. And then, or the other way around, the wife wants to distribute certain kind of property one way, and the husband doesn't want it that way. And then community property assets come into play. So maybe they can distribute community property assets together, or maybe they have separate property assets to distribute. Man, that's a big one, because sometimes spouses don't come to an agreement as to how they want assets distributed, okay? And if that is so, well, what can we do? Maybe we can create some kind of a distribution pattern where you're actually allowed to dispose of 50% of your community property, okay? So if your spouse has, a bank account, they can say that I want, well, I know you disagree with me, but I want at least 50% of this to go to my mother, okay? And they have a right to do so. So how about that? Planning for common goals with your spouse. Number 6 is guardianship nomination. The will has a guardianship provision, and I create a separate guardianship nomination. Guardianship is for who gets to take care of a minor child, okay? So in a situation where something happens to you and you have a child who's under 18, they either become a ward of the state or somebody applies to be their guardian, or you can just nominate them in your documents and say, I want the guardian to be this individual, okay? And man, will that make life much easier and much more destructive to the minor child, okay? So the thing about guardianship is that that's not always the same person as the person who should be managing your finances if you pass away, okay? So it doesn't have to be the same person as the trustee. The trustee may be somebody who's better with money, but the guardian might be somebody who's better with kids, okay? So it doesn't have to be the same person. So nomination of guardianship is very important to people with minor children. Number 7, healthcare decisions if you're incapacitated. We discussed that when I mentioned the healthcare decisions, but that's a crucial form to have, okay? You want somebody to be able to be on the ready to make a healthcare decision for you, and that better be a trusted person. What if it's a person that's close to your family, but you don't trust them, okay? So what if it's, your brother or sister and they're the closest person, but maybe you don't want them to make that medical decision for you, okay? That's not always the case. Families are different, right? If that's one thing I learned, is that everybody has such a different situation. Some people are, beautiful, picture perfect family, everybody's on the same page. Man, I'll tell you, that's 2% of cases. Everybody else always has some kind of a disagreements, a little bit of tension, and in a positive way, maybe somebody's doing really well and somebody's not. So, the people get treated differently for that reason, okay? Number 8, reduce waste if incapacitated. I mentioned that already, okay? So you have to reduce amount of debt you're going to go into, or defaults, if you become incapacitated and there's nobody there to step in and to manage your finances for you, okay? Nobody there to go to the bank for you, take a check and put that check into like a mortgage payment. There's so many people that fall into foreclosure based on the fact that just nobody's around to help, okay? And they haven't done the probate proceeding or any type of proceeding for conservatorship, or somebody has dementia and that's it. They're lights out and nobody is taking care of their assets for them. And, maybe they're either divorced or maybe they're a widow and nobody's there to step in. Maybe their children are away studying or learning. They don't even know about this, okay? So this is a problem, right? Number 9, peace of mind, you guys. More clients tell me about the fact that this is a relief for them, that they don't have to think about this or worry about this, at least for a while. More people are thankful for that than they are for saving, 10, 15 grand when they're passed away. So take a moment to reflect on how much you worked your whole life and how you want that to go to your children. And then take a moment to think, what have I done to make sure that that actually happens? Okay. So with that said, I don't want to go over or summarize anything aside from just saying that there's so many stories of people intending one thing and then realizing that they've done something wrong or didn't do something to protect that on the other side. Okay. So they wish for certain things to happen, but then their documents or their actions don't reflect that in the end. Okay. And that I see most often, and that's my job, to fix that and to plan for that. Okay. So I'd like to leave this with a story of a perfect example for it that just keeps coming back to me. Is that I get a call from a client, it's a woman, and she says, my father passed away, and I say, my condolences. And she says, yeah. And so we have 3 siblings, and my father wanted us during his lifetime to just have this property sold and distributed between us. Okay. And I said, great. Does he have a will? Does he have a living trust? Does he have anything written down anywhere that could prove that? And she says, no. But he did work closely with one of my sisters in order to make sure that something like this happens. And I'm like, great. Does your sister have any proof that this happened? And she said, I don't think so, but the house is in her name already. So everybody should take a pause and think about what that means. And I'll tell you what that means, is that it means that her father no longer owns that property. For financial reasons, he passed that property on to the daughter in hopes that this will not be an issue down the line, and that that property will just get distributed evenly. But guess what? Once he does that, he abandons this property. He no longer owns it. His estate is 0, at least related to that property. And what that means is that sister now owns that property outright. There's no probate, there is no living trust, there's no will, nothing. There's nothing to talk about. She owns that property outright, and it's up to her good, beautiful, wonderful graces to take that property that's worth $1 million or $1.5 million and sell it and divide the assets by 3. Okay. You think she's going to do that? That client never called me back. Okay. So this is a perfect example of lack of documents. A will, will meaning not the documents, but the willingness of the father to divide all the assets by them equally, but not doing anything in between that. And the father committing a crucial mistake of assuming that by doing something else will happen. Okay. And by doing that, he screwed everybody over in the end unintentionally. And I never heard back from the client, but that story is so common. It's shocking how common it is for people to transfer assets with intention of one thing happening and then another thing happening. Okay. Take that same example. I'll leave it on this. Take that same example and say the father added his single daughter as a joint tenant to the title in order to avoid probate. Okay. So he said, okay, I own this property, but I'm going to put my daughter, add her name to the deed, to the title. Guess what? Exactly the same situation. He passes away. She receives that property outright. There's no probate. There's no living trust. She just gets that property. And now the siblings are going to be like, hey, I'm knocking on my wall if you can't see. Hey, your father, our father together, we're all a big happy family. He said that this should be divided between us. And he said, and she'll say, yeah, but it's probably disadvantageous to do so. I don't want to lose this property. My whole family lives here now. Okay. So what do you think that daughter is going to do? You think she's going to divide that house and sell it for $1.5 million? And then from the proceeds of that sale, not being able to buy anything in LA County? I don't think that's what's going to happen. Okay. So I'm done. Thank you for listening. Maybe open it up to a few questions. I know there's probably tons. I just ask you not to tell me personal information about your own potential case, but maybe frame it as a hypothetical. So that way I'm not, solving your problems or giving you advice without, a retainer agreement. I'm an attorney after all, okay? Thank you, guys.
I will say this was very good and informative, and I just want to tell you thank you so much. Unfortunately, I'm not in a position to show my face, but thank you. Just hugely, hugely thank you.
Wonderful, yeah.
Yes, thank
Attorney,
you for all your knowledge. I appreciate it. Thank you for the invitation, Chairman.
you're welcome.
Thank you. And can I say one more thing? If people are planning to maybe log out, my information is right there. Please email me or give me a call. Let's set up an appointment if you need help with something, if you want me to answer a couple of questions. I'd love to do that for you, okay?
Will do. Thank you.
Yeah, this is
I have-
Labanzo.